Welcome to what is an unscheduled episode of the Agents Angle. And as we have always tried to do with the news that is important to the football agents world, we bring you this unscheduled episode. As such, we are recording this episode on Tuesday the 8th of October, and the news broke on Friday, so some 4 days ago now, from the European Court of Justice that involved a case with at the centre of it Alexander-Devlies, FIFpro, FIFA and the Belgian Football Federation. And not to forget Jean-Louis Dupont, known as the lawyer in the Bosman ruling. And we have spoken about the case in past episodes, not just this season, but Peter, you highlighted this case many months ago as one to watch, way before some in football had even started to talk about it. So do you want to give those listening, and me, a brief and basic synopsis to the background of the case?
Thank you, Jonathan. Yes, this case has lit up LinkedIn, lit up all the football lawyers. I can see a lot of attention to the case worldwide. The case is the DIARRA case. We've discussed it before, and everyone says it's a Bosman. We'll see that in due course. But just to give a bit of background, and without repeating myself, because we've mentioned a bit of the background in previous episodes, this case stretches back to 2014 when DIARRA, who was playing for Lokomotiv Moscow, he was, I believe, a French international at the time, he was in dispute with his club over his performance, but also the wages. Now, Lokomotiv decided this amounted to a breach of contract and terminated it in terms of his conduct. They took DIARRA to FIFA's dispute resolution chamber seeking damages. The dispute resolution chamber at the time did find in favour of the Russian club and fined the player over 10 million euros. DIARRA at the time also received an offer from a Belgian club, Charleroi, and that was really on confirmation from FIFA that he would be able to move to this new club without being liable of any of the costs owed to Lokomotiv. And this is the essence of the case, because this case, which has ended up in the European Court of Justice, came from a Belgian court which looked at these facts on behalf of DIARRA. So it's basically a Belgian case. European law applies, competition law applies, and that flows on to FIFA's dispute resolution chamber and FIFA's power generally. 3 questions that the European Court of Justice was asked to look at from the Belgian court, who wanted clarification, especially on restriction of players being able to get new employment and also about movement of players, in essence, competition law. So 3 questions were, the first one, that the court made a decision on any party that terminates a contract without just cause is liable to pay compensation to the other party. So FIFA law, or the RSTP as we call it, has a provision for just cause, but if you terminate it without just cause, you will have to pay compensation, say in this case to the former club. What is just cause? Something like if a club owes you a lot of wages, then you can terminate unilaterally. But in this occasion, the DIARRA seemed to not have just cause. The second question the European Court of Justice looked at in the DIARRA case was whether the player, when they join a new club, the player and the buying club, in this case a Charleroi, who wanted DIARRA, are both joint and severally liable to pay any damages. So any damages the dispute resolution chamber of FIFA decided on, they would be both jointly liable. And that was another provision of the RSTP that the court looked at. And finally, the sporting sanctions part of it, where if a contract is terminated without just cause, that was alleged against DIARRA, that he left the club without just cause, sporting sanctions, so you can't play anymore, will be imposed on both the player and the buying club, the club he would go to next, if they were seen to induce that breach of contract. Now, that was another provision that was looked at. And sporting sanctions for a buying club might be a transfer window, or you can't register players for 6 months. So it has big implications. The ruling, and I really actually need to read the full English version because what's come out is mainly the French version. It is a Belgian court which decided, and the European Court of Justice in Luxembourg came out with a French language decision. How does it affect several provisions of the RSTP which affect transfers and player contracts? From looking at the decision, it seems it does. Whether it's a Bosman, the jury's out. I'm sure we'll address that in due course, but we need time to see the impact of this case. A lot of experts, I see football lawyers on LinkedIn say it may lead to greater player freedom or greater player power to make decisions about their contracts, which inevitably would mean instability in the football transfer market, as players who are disgruntled, who want to change or want to go to a more successful club will be more inclined to move to those clubs, even when they're under contract and not free agents, Jonathan. But that's the essence of this decision. Obviously, we'll get to know more in this flash episode with our guest. But they're the big questions that this court answered.
Now, on Friday, after the ruling was announced in the morning and over the weekend, as you rightly say, there's been a lot of commentary on this case. Quite a lot of legal analysis from various quarters and a lot of opinion from not just lawyers, but also many others. But for me, it is a big ruling for football, which definitely impacts agents. But we will have to wait weeks, months, and years to see how this pans out and what the effect will be. The Bosman ruling did change things overnight, but it took time to have an impact, time to evolve, and that has led to changes in football that I doubt many predicted accurately at the time of that ruling. And one person's opinion at this time as to the long-term effect this ruling will have is really no better than anyone else's. But what we wanted to do with this special episode of The Agent's Angle is really give a basic and non-too-legal assessment of what this case could mean for agents and agent activity in the future. Not so much a forensic examination of the case and the ruling, as some may have wanted, and try and avoid what I refer to as the language of legalese.
Yes, we're an agents podcast, Jonathan, so we really got to look at the agent's perspective, how this case affects agents. Us agents, we engage in the transfer of players, including free players and contracted players. So if there's going to be implications going forward from this case, agents need to know how that's going to work. Not just agents, clubs, leagues, and of course, the FIFA RSTP. It is, we know, an European decision, but any changes to the RSTP, being the international transfer architecture, I would call it, that applies to everyone, will have an impact worldwide. And any RSTP change that comes out of the DIARRA case, just like it did with the Bosman case, will have a big effect on agents. As I mentioned earlier, they say that agents and players will have more power to move or organise move for clients. But it's very early days at the moment. We don't know the long-term implications. What I think we do want to know is it's a Belgian case, so we need a bit of a Belgian flavour here. And we need someone who's more specialised in the Belgian court, because ultimately, although the European Court of Justice made the decision, it goes back to the Belgian court to look at the precedent, the case, what's been decided, what opinions been given, and implement that in the Belgian case and how that flows through. So I think we need someone specialised in Belgian law. In particular, I would say sports law and competition law, and also EU law. So let's turn to our guest for today. And it's Willem Alexander-Devlies, who's based in Brussels. He works for the LTS law firm. He's a Belgian attorney at law with the Brussels Bar, has a wide range of national and international clients' experience in sports law, including regulatory matters, disciplinary proceedings, and employment-related disputes. He's provided legal representation to clubs, agents, intermediaries, athletes within the Belgian state courts, the Royal Belgian Football Association, the Belgian Court of Arbitration of Sport, FIFA, and HAS, the Court of Arbitration of Sport. Willem, welcome to the podcast.
Thank you very much. Happy to be here.
We really appreciate you coming on at short notice, and also to come on this very important topic, the DIARRA case, which has been like the news on fire on LinkedIn with a lot of sports law specialists, with everybody really involved in the football world, especially the football regulatory and legal world. I just want to start off to get straight to the decision itself, the DIARRA decision. Can you just run us briefly through what the decision was, and were you surprised by the ruling by the European Court of Justice?
Well, I don't know if it's important to get back to the facts of the case itself or just the decision of the ECJ. But mainly it goes about Article 17 of the RSTP in relation to when a player or a club terminates a contract with or without just cause and compensation needs to be paid. There are provisions that provide for the joint liability of the new club if a player signs a new contract afterwards, as well as potential sporting sanctions for the new club and the player in that case. And what the ECJ decided was that these provisions actually do restrict the free movement of workers within the European context, because Article 17 imposes considerable legal risks, also unforeseeable and potentially very high financial risks, as well as major sporting risks on both players and clubs who wish to employ the players who terminate their contract. And so the court says that these rules, they impede actually the international transfers of those players, and this is a problem. So then secondly, the court considered whether these rules can be justified. There are always two questions. One is, do they have a legitimate objective? And if so, are they proportionate to attain that objective? I think on the first point, the court said yes, and said indeed there is a legitimate objective in these provisions, ensuring the regularity of inter-club football competitions. And that's also something that FIFA celebrated, because it's actually a way that you can accept us as a way to preserve some form of transfer system in the future. So the rules have a legitimate objective to exist. But on the second question, whether or not these rules were proportionate, the court was also very clear that they were not proportionate at all, and even manifestly disproportionate as they are now. So the first criteria was the fact on how the calculation is made of the financial compensation that a player needs to pay when he breaches his contract without just cause, because it fails to take properly into account national labor law, and also the fact that the specificity of sport criteria, which is also mentioned in Article 17, it's too vague. And so when you terminate a contract player, it's too difficult for players to foresee how much the compensation will be. And the criteria used can lead to enormous amounts of compensation that needs to be paid. So according to the court, this is in a disproportionate way on how this compensation needs to be calculated, or at least how the regulations are written in a way that it's not clear for the player or the new club to know how much needs to be paid. Also, the criteria of the joint liability of the new club, it's disproportionate, because the liability exists automatically, and so there is no needs to be an actual role of the new club in the breach of the contract. Only for the sporting sanction that can be applied, there is a possibility to prove that the club did not induce the player. But for the joint liability to pay the compensation, it's presumed automatically, even if the new club didn't do anything, it's automatically, and that for the court is also disproportionate. And then you have the second part of the decision is about the fact that the provisions of RSTP were also in violation of Article 101 about distortion of competition law. So the court was very harsh in its decision, stating that the Article 17 and the rules provided constitute actually a general and drastic restriction of competition between clubs to recruit the players. And according to the court, it's a restriction by object, so it cannot be justified according to the jurisprudence known as the Wouters or the Mecca-Medina test. Can only be justified in very, very strict tests under Article 101, paragraph 3. And so as a conclusion, the court actually said that the provisions of Article 17 are violating the freedom of movement of workers, and also they distort competition between the clubs in Europe. In short, a summary of the decision. Was it a surprise? No, because already in April, the Advocate General, Bunach, made actually the same conclusion. So he also said that there was probably a violation of freedom of movement and distortion of competition. And in general, the court, they follow these opinions of their Advocate Generals. So I think most people actually expected, or at least the lawyers or people with legal background expected this decision.
From your Belgian sports lawyer perspective, this case goes now back to the Belgian court who referred the matter. Why is that? Is it just part of the process? And what could be the further developments in the case that the Belgian court will apply now that it's received the ECJ decision?
It goes indeed back to Belgian court, because that's where it started. I mean, the Belgian case was already started already, I think, in 2015, when it was clear that DIARRA to wait for at least 11 months before he was able to find a new club. And according to DIARRA, it was FIFAs and the RBFAs, Belgian Football Association, It was their fault that he had an enormous loss of earnings because he could not find a new club because of these rules in Article 17. So he filed a claim before the commercial court in Charleroi, and he requested 6 million euros in damages from FIFA and the RBFA. And in January 17, the commercial court of Charleroi accepted his claim and said that indeed the rules are problematic and prevented him to find a new club, but decided to award provisionally only 60,000 euros in damages and then refer the case to the roll. So if parties wanted to pick it up on the topic on the amount of compensation, they need to file new submissions again, and then the case can be decided again. But on the topic on the liability, FIFA appealed this decision with the Court of Appeal of Mons in February 17. And in September 22, the Court of Mons, they also saw that there were potential problems with the provisions of Article 17 in relation to European law. There were, of course, provided a lot of arguments by the lawyers of DIARRA why this would be the case, but they were not willing to take a decision immediately, so they decided to question the European Court for a preliminary ruling on these topics, and so they asked the court these Article 17 provisions would violate Article 45 and 101 of the Treaty on Functioning of the European Union. And now in October 24, we have this answer of the court that there is indeed a violation. So now the case goes back to the Court of Appeal in Mons, the answer to that question. So yes, there is violation. So the Court of Appeal will now make its final decision based on this European decision, and will have to decide whether or not FIFA and the RBFA have indeed liability towards DIARRA, his loss of earnings, and if they will have to pay compensation or not. So that's why that's actually the merits of the case. And then if they confirm the decision of the commercial court of Charleroi, so the first instance decision, then probably the case will go back again there to then have a discussion on the exact amount that needs to be paid. So that's the reason why it goes back to Belgium now and to go back to the merits of the case, whether or not FIFA is financially liable towards DIARRA for his loss of earnings.
And of course, this is a European ruling, and that will be the first thing that a lot of people notice. And they might ask questions about how much of an impact it will have across the world. Also considering matters that you've got the UK's relationship with Europe, and there we have the English Premier League's influence on football. And also, although FIFA's a Swiss entity still, their legal hub is now in the US. Can you just explain what may well be the impact of this ruling across the world?
I mean, it's not because it's a European-based decision that there will be no impact. We saw it as well with Bosman. At the time, it was also the European Court that made the decision, and that actually forced FIFA to change its regulations. And I think now will be exactly the same. FIFA will probably amend Article 17 accordingly, and the rules will follow for worldwide. They will not make a separate exception, I think, for Europe. They will just amend the regulations. Also, the fact that FIFA now has moved its legal hub to the US, for me, it will not make any difference. If in the future as well, if there will be new cases on European law where players or club through a lawyer will fight the illegality of certain provisions of the RSTP, then we will come in exact same situation. There will be a decision of the European Court, and if it's saying that FIFA is violating competition law or whatever European law, FIFA will have to change it. And because it's an international body, international sport, chances are that they will change it internationally and not only for Europe. I think so far there's only one rule in the RSTP that makes a difference on Europe or internationally, and it's about the training compensation rules. But I think here it will have an impact on football at the international level, and everything will change, and not only in Europe, also the UK, the US.
At the core of this case, and you rightly pointed it out already, that we have the FIFA RSTP and the aspect of just cause. But when it comes to players, player registrations and player contracts, how do you see it impacting those?
I think that there are several consequences of the judgment, and I think the first one is that FIFA will have to amend the RSTP, at least Article 17, the provisions that were part of the decision. Question will be more on how will they do it, because they did not really do it proactively. For them, they see, okay, it's just one or two or three provisions from the RSTP we need to change. Question is, will they completely get them out of the regulations or not? And who will be involved in the change of the regulations? Will they ask everyone, all stakeholders at the table or not? I don't know. I hope so. That's the first one. The regulations will be changed, and they will be changed for the future. So there will be no impact on the existing contract and registrations. There might be maybe potential new cases on financial compensation. Other players or clubs that felt that they had damages because of this rule. A second thing is that for the future is that probably the calculation of compensation in the event of termination of contract will also be changing, maybe back more to in relation to the Webster case, where they look more at the residual value of the contract rather than transfer fees, replacement costs, calculations actually based on very uncertain and out of thin air calculations on what is the value of a player. I think the focus will be more again on national labor law and how much, according to national laws or CBA's, calculation is when a contract is terminated before its term. And then the joint liability of the new club, if it's still maintained, because the decision of the ECJ leaves an option that it can be maintained, but then it will be considerably weakened probably, because there needs to be some kind of burden of proof for the new club that he will be able to prove that he didn't do it, or even better, other way around, that it has to be proven that the new club induced a breach of contract. So that rule will probably change. And then lastly, I think in general, the economy of football, now the transfer system have a redistributive function of the money in the world of football, and a lot of the money comes in by television deals, especially, for example, in the Premier League. And these monies are divided through the other leagues, usually by transfers, and smaller competitions do big transfers and they survive for another year. The transfer fees, they might change because it will be cheaper just to terminate a contract unilaterally and pay the compensation based on the value of the contract rather than on crazy transfer fee amounts. There will be a shifting from the transfer fee system, and the transfer system itself will probably stay because there is also a legitimate objective in the system, but it's more the fees will maybe disappear or will be lower because it will be cheaper to just ask the player to terminate the contract and then pay the fee for termination rather than a transfer fee based on, I don't know, transfer market. I don't know how people get to these crazy amounts, but that will change. So I think these are the main consequences of the decision.
Willem, a lot of our listeners are football agents. You work with a lot of football agencies, both large and small, as well as some top players and clubs, including some of the major Belgian clubs. What do you foresee being the impact for agents and others, both short-term and long-term, even in the next key transfer window, which is coming up? So what's the impact, you think, on agents in the next period?
I think, especially on the long term, the bargaining power of players will increase. Now the clubs have more power because they have the financial means and they know in principle that they're protected for the duration of the contract, and because new clubs will be sanctioned if they force or if they induce players to terminate a contract. So if that disappears, then the employment contract will be more important than a transfer agreement. I think especially for players' agents, they will have more power to negotiate on contract signings, contract terminations. I think, as I said, I think there will be a shift from the focus on transfer fees more to focus on player salaries and the compensations payable. I think the role of national labor law in each country will be more important. So agents, together with competent lawyers, will need to expand their knowledge more and get more acquainted with the labor laws or contract laws of a certain country where they do transactions. And I think on the short term now, for example, the first window in January, although there will be no final decision by then in the Belgian case, because now we have this European decision, but it's more an answer to a question, and it's now for the Belgian court to make a final decision on whether or not the rules were in violation and whether or not FIFA has liability towards DIARRA. I think that the decision of the ECJ was so clear and so condemning towards FIFA and the provisions of the RSTP that now in the winter window in January, a lot of players and probably their agents will use this decision to pressure transfers and so to pressure clubs to agree on an early termination of the contract. I think we might see more unilateral terminations, as certain clubs probably hope to get still a big transfer fee for some of their talents. But if there is no agreement or a potential new club is not willing to pay this, players might use national law to just terminate unilaterally, pay a much lower fee based on national labor law and leave. And I think we've seen this in the summer window that was now the recent summer window. There was a lot of transfers. I mean, I think clubs and players, they expected a decision to be negative as it was now. And so they tried to do a lot of transfers. But we also noticed that the threat of unilateral termination in advance of the decision of the ECJ was already used also this summer. So they did not terminate, but they used the argument of the ECJ and the fact that they could terminate based on national labor law to put pressure on clubs to agree on free transfer or a lower transfer fee. And I think we will see that now more in January, that the threat or the actual terminations, there will be more of these cases rather than only transfers involving transfer fees.
Willem, I've got one final question before we close off. Do you think, from a personal point of view, the DIARRA case outcome will affect the European Court of Justice consideration of the upcoming case on the FIFA football agents regulations, which is also at the European Court of Justice after referral from some German courts? Do you think this DIARRA case outcome will influence the decision in the FFAR, or is that too difficult to predict?
Well, I don't know if it's going to influence it, but it's at least I think it will have a positive effect for agents in that the ECJ will also condemn the FAR provisions that are against European competition law. I think, as we saw as well now in the decision of DIARRA, the court referred a lot to previous cases, the December cases, including the Super League case and the Antwerp Refailov case. So the chances are that indeed in the FAR case, the European Court will also look back at the DIARRA case. And since in DIARRA, the court was very convincing about the illegality of these RSTP provisions, I think it increases the chances, or as well in the FAR case, that the ECJ will again say that some of these FAR provisions are indeed in violation with European law and are going too far and cannot be justified. So I think that it will be a positive effect, or at least it can be positive. Not sure if there will be a direct influence, but it's better for the chances for a positive outcome in the view of agents, of course. Probably it's a good thing, the DIARRA case. Yeah.
Willem, thank you so much for your time. We really appreciate your insights and your breakdown of the DIARRA case and its implications, not just in Europe, but worldwide. Thank you for coming on to the Agents Angle.
No problem. My pleasure.
Great to get an insight there from Willem as someone who has an appreciation of the various aspects of this ruling, but also appreciates the practicalities of the football world, not least the world of football agents and football agency.
Yes, very informed opinion and view there by Willem. Interestingly, I believe his firm advises Kevin De Bruyne, the Manchester City winger or striker, in terms of his deals and obviously next deals, and also in terms of some of the data and all that he's put forward. Very interesting that Willem's firm also advises, provide that legal perspective. But going back to what Willem said, pretty much it stands out here that this decision's about free movement of players, especially, Jonathan, when you look at players have very short careers. So if you have to pay a penalty to get out of a contract, a very high penalty, you don't know if you're going to have 5 more games left. So there is that sort of, I think, public policy issue behind this. The European Union looks at for freedom of movement of workers, but in this case, professional footballers. Also, competition law, restricting cross-border competition was looked at here. A very important doctrine where European clubs have to have some sort of stability in that. And we know that this decision, the European Union is very strong on making sure that nothing's too anti-competitive unless it has, some sort of purpose underlying it. So what are the conclusions? I would say, I don't think it's the end of the transfer markets or the transfer periods or transfer windows, but there will be major repercussions in the football regulatory landscape. I agree with Willem. The FIFA may have to consider amending the RSTP to bring it in line with EU law, and in particular Article 17, which sets out those consequences of a breach of contract without just cause. So that's sort of my short takings from what Willem said, and he's at the forefront of the DIARRA case. It is a Belgian case and really provide us with some fantastic information for our listeners, Jonathan.
But as we've already discussed, some people have really gone into overdrive with this case, saying it's an earthquake akin to Bosman, probably a bit to do with DuPont being the main lawyer once again, while some more pro-FIFA people and FIFA themselves have actually downplayed it. And I think FIFA's chief legal and compliance officer, Emilio Garcia Silvero, was reported as saying, "It is important to clarify that today's decision does not change the core principles of the transfer system at all." But I think our view, Peter, is probably at the moment more aligned to the reported comments from FIFpro, who supported Lassana Diarra in this case. And they reportedly said it was a major ruling and that it will change the landscape of football, but also balanced that by adding in that they would be analysing the ruling in depth, all of which I can't say I disagree with FIFpro in the slightest with that.
Yes, FIFpro at the forefront of this case, so the implications are important for players, but also for FIFpro as a player union going forward, they may have a role, because a lot of people are mentioning now we may end up with a system of collective bargaining like they have in the US and even in Australia in terms of salary and transfer systems. But one thing's got to be clear here, Jonathan. The DIARRA ruling mentions that part of these regulations are unlawful, the 2-3 that were mentioned by Willem, but it doesn't detail exactly how you would change them. That's the important part. So where does FIFA go here? Do they draw a new set of regulations or amend Article 17 and maybe one or two other articles? That's not clear, and we need to be aware of that. The other important thing is, as I mentioned, collective bargaining between players and employers might be the way to go to overcome these sort of rulings, these competition law and freedom of movement rulings, where if all the parties get together like they do in the US, when I say US, I say the major sports in the US, like they do in Australia and a few other countries, they come together. There's a dialogue around setting up a mechanism where all the parties agree, the player union, the players, not saying the agents on these occasions, but the clubs, federations, and of course, FIFpro or the player union in that country. So that may be one of the answers coming out of this. I don't know, but it's very, very important that this is a turning point for player relations, player opportunities in transfers and moving clubs, but also how the clubs are going to react. And I haven't seen much from ECA, the European Club Association, but it'll be interesting what their perspective is on this case. So it's very, very interesting that is coming forward. I've seen a couple of statements, Jonathan, just briefly. The European Football Agents Association has made a statement as one of the agent associations in the world. They've said that it is a turning point, like I mentioned earlier. It's marking a pivotal moment in the dynamic between clubs and players, and they want to see an urgent need for a balanced approach to modern football's transfer system. The TFF, the Football Forum, also an agent association, have also said in one of their media releases or social media releases that the FIFA rules, the ECJ rule, that international transfer rules, some of them that were mentioned earlier, were contrary to EU law and do impede the free movement of footballers. That's the background there from a couple of the agent associations, Jonathan.
Now, as a layperson, as I'm not a lawyer, as everyone knows, they only have to listen to the podcast to know that, I think the ruling just takes the matter of player contracts and player registrations out of the so-called court of FIFA and away from FIFA law as such. And in that sense, it becomes, for me, much the same as most commercial agreements or contracts, but understandably with an employment law, labour law, and human rights element to it. If someone breaches a contract, the The real law adjudicates on the issues and imposes a ruling. It doesn't rule out the parties going to the courts and litigating, an independent tribunal and arbitration, or even mediation. So in a way, this is, to me, the Webster ruling, as we spoke about on the last episode, but really supercharged. And we've already seen an element of this in certain territories where players are permitted to buy themselves out of their playing contracts with a club, and the money they use is often given to them by their next club to buy themselves out.
Now we're moving into territory of the Spanish buyout clause, the famous Spanish buyout clause. Just briefly for our listeners, in Spain, there is an employment law that gives each player, each worker, the right, in theory, to break their contract at any time to join a new club. However, the player's original team or current club will be still due a fee. And that's got to be determined, the way the law is, by a third-party valuation with courts that deal with these sort of labour or contract disputes. However, to make things easier in Spain, that process takes a long time to go through courts. We all know that. And to come to a selling club valuation, we know we've had a lot of controversy. What is the value of players? And even Willem mentioned some astronomical transfer fees that have been paid and the impact this DIARRA case might have on that. What happens in Spain, and this may be an outcome to the rest of Europe or the world, that we start seeing more buyout clauses, release clauses, in other words, where a player's contract is set up where if they need to go or they unilaterally want to terminate, there is an amount that's agreed between the parties that has to be fought out. So an amount that's, I would say, viable for a club to buy the player or transfer the player. Or, as you said, Jonathan, what happens is essentially the player will buy out his contract, but the engaging club, as we call it, will give the money to the player to pay the club. Now, all I will say is we need to get moving on things, whatever happens at the outcome of this case, because we have got another transfer window. We need some clarity. So it'll be very interesting to see what FIFA's next moves are in this matter.
And this will definitely get me off FIFA's Christmas card list for another year, if I was ever on the list in the first place. In many ways, I think this ruling is a very good thing that we've taken everything into account. Yes, I have some concerns as to how some unscrupulous elements in football, including some in the agents world, will try to exploit the ruling for their own personal gain. But litigation isn't quick and arbitration can take time. But if you remove one distraction, namely FIFA law, from the process, along with any other related interference, such things will probably move a lot faster. And players and clubs need to get on with things and need certainty in such a fast-moving industry.
Yeah, I agree. It is a fast-moving industry and transfers and seasons come and go very quickly. You're right. Civil litigation takes time, obviously depending on the jurisdiction. Right now, we probably need a mechanism in place for FIFA, local associations, FIFpro, everyone to get around the table. Maybe the courts are not the answer at the moment. Maybe there's room for mediation here, Jonathan.
But from an agent's perspective, there will be changes coming once the Belgian courts have tied up those loose ends in this case. I think we'll start to see changes where they're fast or slow, and as such, agents need to keep a sharp eye on these developments. It's certainly good news for the lawyers, yet again, as they will need to work with players, clubs and agents in drafting and redrafting contracts, whether they be player contracts or even agent rep agreements, because those will be affected as well. And as soon as that ruling dropped on Friday, it is safe to say that quite a few agents and their lawyers would have been thinking of ways how they could utilise this ruling in the future, if not even in the next transfer window, which is just 3 months away for many. But I think we better avoid the topic of transfer windows until the next episode, because we've had an announcement there as well in the last week. RSTP will no doubt need refinement, but this is all part of the job for professional football agents to evolve and adapt to these changes. But there is an elephant in the room in all of this, and you touched on it with the interview with Willem. Where does this leave FIFA in regards to other challenges, not least the FFAR cases due at the ECJ, which could be expedited off the back of the DIARRA case, with the ECJ maybe having a taste for football at the moment? Because some of those cases question FIFA's legitimacy and authority to regulate on some non-sporting elements linked in a way to those in the DIARRA case. And with that, you and I both saw a post on LinkedIn from a well-respected sports barrister, John Merzad, and he looked beyond trying to make predictions and overanalyzing the DIARRA case specifically, And John made me think whether this was another sign of a power shift when it comes to the control of sports governing bodies. And I think that begs the question as to whether the likes of FIFA and other sports governing bodies have come to a point where they've overreached in terms of their remit and control over people, clubs, and other entities. And in overreaching, they're being put in their place now by various courts and laws, of which this is just one example.
Yes, that's a big question now, because we've got to remember it's a private association, in essence, FIFA, and some of these decisions say it's really national legislation or national regulators that have to look at these things. But also this case raises a couple of other areas, Jonathan. The international transfer certificate is another area that may need to be clarified from this decision, how that it's released. We know if a player moves overseas, their ITC needs to be released. There is a process there, which sometimes is a bit limiting. But also, and I read a French lawyer raised this, that there may be a knock-on for minors in regulations already raised following the DIARRA ruling, and that there might be pressure down the track to look at another article of FIFA regulation in the RSTP, Article 19, which prohibits transfer minors, and that could be a challenge on European competition law. Not sure what's happening in that area, but this French lawyer that I read, he mentions that may be the next area where maybe FIFA is challenged on. I'm not sure if that's going to happen, but a very interesting point, especially after the outcome of the DIARRA case. And from there, it's time to farewell, everyone. We really appreciate you listening to this, what we call a flash episode. But the DIARRA case is going to have a big impact on agents going forward once we know the clear position of where it's all going to head. So from me, bye.
Yes, we are now off to finish the scheduled episode of the Agents Angle for this week, which, all being well, will be out on Sunday as planned. So until then, take care everyone, and bye for now.
The purpose of the Agents Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.